very special guest, Brian Hinman. In this class, we'll spend a lot of time discussing how real value comes in today's world from intangible assets. What's on the balance sheet often is unimportant, except for cash, of course. Cash always matters. And what's not on the balance sheet is really where the action is and where the value is. And because our accounting systems are very slow at coming around to this point of view, because accountants love precision, and when you're talking about intangible assets, it's very hard to be precise, but it doesn't mean to say you should ignore them just because you can't be precise. And there are a few leaders in the world, and Brian is one of them, that have been focused on rigorously driving intellectual property strategy through the corporate world to make sure that the companies that actually are the pioneers that actually create value also get to share in the returns, and it doesn't just all leak out to competitors and others. For many years, Brian was at NV Phillips. Well, he first, I think, started at IBM, but was at NV Phillips, where he had 400 professionals working for him, making sure that every division in Phillips, as I understand it, every department or every product line really had an IP strategy and was paying attention to these kinds of issues. And there's a lot of talk about doing things like that, but very few companies actually figure out how to do it. And Brian is a leader in that. In recent years, he's joined Aon, which is an insurance company, of course, or a capital markets-based company, where he is the chief innovation officer and has been building some creative new businesses and some new financial products, which have as loose collateral the intangible assets of the companies. So he's found a niche, a gap, if you will, in the capital markets, and it's really quite something. Capital markets are incredibly well developed in the United States, but Brian has created another opportunity for financing of typically early stage venture companies that are looking to borrow rather than to necessarily use equity. So they don't necessarily want to use equity, which is very expensive, and there's very limited amount of debt available. And at Aon, as I understand it, he's invented some new products and has considerable flow of financial resources into early stage companies to help supplement what's available from the venture capital market. So without more, let me hand it over to Brian. I'll let him begin where he wishes, because he has a distinctive view on these issues and has had very considerable experience. And I know I'm going to learn a lot, and I know you are too. So without more, Brian, thank you very much for giving us your valuable time, and the floor is yours.
Thank you very much, Professor Teece. It's very nice to be introduced to your class, and I'm going to touch on a lot of different topics tonight, but I'm going to try and bring in, as you say, the corporate perspective on intellectual property as, trying to establish, and I know the world has been trying to establish it as a separate asset class, and that's really what I've been all about in my career, is to try and break through a lot of glass ceilings and to try and bring and instill a culture into a C-suite of a company. And I've instilled that in companies like IBM, where I was the chief IP officer. Verizon, I led their intellectual property practice. And Philips, of course, my most recent corporate experience. And then I've seen the other side of the table too, where I founded a couple of companies that fight against the evil empire of the patent trolls. And I'm sure you probably have been talking about these guys, but essentially patent companies that acquire patents to go out and litigate against operating companies. And so I founded Allied Security Trust and Unified Patents to try and really look at it. So I've seen the spectrum of defense and offense, building up a large monetization practice in some of the companies that I work for, and I'll talk about that, but really on the strategic angle of really looking at how intellectual property can be a differentiator for a company is really where I wanted to focus. So I'm going to share my screen. Hopefully this will cooperate with me today. You should be able to see a chart here. It says empowering innovation through intellectual property. Can you see that?
Not yet.
Oh,
Ah, there it is. We got it.
okay.
At least I
Good.
have it.
I'll try and make it a large screen here so everyone can see it. And really, it's empowering innovations because companies, when they are innovating, and that's really when I was at Philips, for instance, when I first joined, I was based in the Netherlands. So I'm going to bring a world view here, right? So I had a large practice in Asia with teams in Taiwan, in Shanghai, and also in Singapore, and also in Japan, in Tokyo. And I also was based in the Netherlands when I was at Philips. So I was based in Eindhoven, which is the headquarters of the research. And I reported directly to the CEO of the company. And that really is the importance of how Philips placed intellectual property. It's very, very rare. Matter of fact, I think it's the only company in the world where the chief intellectual property officer reports directly to the CEO of the company and is part of the executive committee, which is the top 8 individuals within the company and that's where they make the executive decisions. I was part of that from day one. And he asked me, he said, you want to be in a corporate office in Amsterdam sitting next to me, or where do you want to be? And I said, I want to be where it happens. And that's really next to the R&D organization. I would be next to the CTO. And so that's where I planted my team. And the reason why is because that's where innovation happens, right? It happens in the product units within a company, but most importantly, within the R&D units, where we spend 10% of our budget every year. So why not be there as it happens? And I'll give you some more stories of innovative things that we did with some of those inventions and innovations. But really want to start with talking about protecting innovation. I know you guys have probably seen this chart, or certainly know the history of the patents, starting with the 1790 Patent Act. You know, it took us up until 1911 to get to our first millionth patent. But half of the US patents, if you can imagine, we're up to over 10 million now, but half of the US patents have been issued in the last 27 years, the last 1 million issuing in the last 3 years. So we've exploded in innovation. We're an innovation-driven economy. I remember talking with Yanku, who was the outgoing USPTO director, when he signed that 10 millionth patent. And it was an earth-shattering experience just talking to him and getting his perspective on this. But it's something where companies have to act quickly, particularly, and I know you guys are out in California, a lot of you are, where a lot of the innovation happens. I talked to some of the attorneys at Goodwin Procter today. They represent 14,000 startups in the Valley, 14,000 startups that are trying to capture the innovation. So every business is being disruptive. They're forced to innovate. They've got limited budgets and they have to figure out what to do with those budgets, right? But most importantly, they have to act quickly because the world changes. Data collected through innovation provides insights, but innovation is not enough. You have to capture it and convert that innovation into IP assets. It's so important to do. So that's the first disruptor. The second disruptor is that there has been this unprecedented value rotation. So if you look over on the bottom right, you see in 1975, the world was a far different place. My alma mater, IBM, was sitting on top of the S&P 500. And you see some of the big capital-intensive companies like ExxonMobil and GE and 3M. 85% of the world's value was in intangibles. So basically, property, plants, and equipment, and very little focused on intangibles, of which IP is a very large portion. Fast forward to today, and you're looking at the makeup of the S&P 500 now, and you're looking at companies like Apple and Alphabet, Microsoft, Amazon, and Facebook, right, that you wouldn't anticipate. So a lot of these capital-intensive companies, the value has been supplanted by intellectual property, and now roughly 75, 80% of the value of the S&P 500, or roughly $21 trillion in intangible assets, are focused on intangibles and far less on the world of tangibles. So now with that rotation to become more of an intangible-focused economy, you know, I often ask companies when we advise them, what are you doing to protect, or how are you converting the value that you've got into revenue? How are you making that translation from innovation into revenue, into real results that come to the bottom line? Because that's what's happening. So there's been a lot of things that have changed, such as theft of IP that I'll talk about, which is really cybercrime, trade secret theft. a lot having to do with China, but not just China, but we've got lots of mobile employees now that you've seen the Uber case where an employee leaves to form his own company, taking autonomous vehicle technology with him, thinking, hey, I can do this and impress my new boss or start my new company, but unfortunately it's illegal and bad things can happen. So you're seeing lots of that. You're seeing lots of money being thrown at in VC transactions and a lot of liability suits, a lot of very expensive patent litigations. You read about them every day. It's a great quote from a guy that I met when I was doing the patent cross license between IBM and Microsoft back in the day. Very important deal. And I sat in front of him and he got it, right? I mean, this quote back in 2004, he's saying it's imperative for CEOs not just to have a general understanding of the issues, but to have a refined expertise relating to the issues. You have to have the ability to formulate strategies that capitalize on and maximize the value of their company's IP assets. So he hires a guy named Marshall Phelps. Marshall Phelps was my predecessor at IBM, who ran the IP organization and was my mentor that I took over when he retired. Now Marshall and I are on several boards together. So, but it's important for you to realize that this goes way back. This goes back into, back in the 90s and early 2000s, there were only a handful of companies that really got it at that level, at that CEO level. Bill Gates was one of them. My old boss, Lou Gerstner, who was one of the most prolific CEOs ever, was my boss and CEO at IBM, was another guy that got it. But you're looking at, this is an interesting statistic here because it's the only vehicle that converts innovation into legally recognizable intangible assets. I'm going to ask the audience how many patents they think are in the cell phone. Just a rough, wild ass guess without looking and up and on the internet.
15,000.
15,000. 250,000 patents are in and related to every feature imaginable on the cell phone, which includes the haptics, includes the apps, includes the functionality, the microchips, everything in it. That's a ton of patents. But you have to understand there's a lot of other things that go around it. You got the trademarks and the copyrights and the trade secrets. Just by virtue of the patents, now you can understand why the cell phone wars existed and why they continue to evolve as we get into 4G and 5G. And now there'll be other generations beyond that. So it becomes a weapon that companies are using to protect their ecosystem. Because don't forget, a patent doesn't give you the right to do it. It gives you the right to exclude others from doing something, right? So it's a negative right. It's not a right, it's a negative right. That's what a patent does. So you have to recognize that. This is a great product that we used to sell at Philips. And I used to bring this to the attention of my executive committee every now and again to understand the intricacy of what I call integrated intellectual asset management, which simply means you're integrating all different aspects of IP. In this case, we have our Norelco razor, which has a great brand, the Norelco brand, which is a sub-brand under Philips, but you have the technical features, which are protected by patents. The shape was a design actually that I enforced, did a lot of enforcement against companies like Braun that captured that design and intricacy of that. We enforced that. The know-how having to do with classifying in this case, the manufacturing of the razor heads. Dropton was a town in northern Netherlands where they manufactured the razor heads on this device. And the manufacturing facility, we kept all of that trade secret because we didn't want to file the patent. When you file a patent, you're actually telling the world what you're doing, right? You got a patent claim that says, I have a device that does X and Y and Z. It doesn't give you the secret sauce on how to do it, but it does tell you what you're doing. And in this case, we didn't want to. So we kept all of that manufacturing process of the way the curved shaver heads are manufactured and how that works in the process, kept all of that as a trade secret by design. And the algorithms, of course, the way this has connectivity as a smart device, and then the online presence. So this is a great example of an integrated device, but it goes into the whole methodology of strategy as a company, because you can't just think about, I'm a patent attorney, all I'm going to be concerned about is filing patents, because when you are in the room with an R&D organization, the time to bring the IP attorney into the room is right when you have the product conception of an idea. I have an idea, I want to design a new product, and you have to make 3 decisions, right? Or a decision that has 3 outcomes. You either have to protect it by trade secret, protect it by patent, filing a patent, or you want to publish it. publish the idea because you want the world to know. But it's a fundamental business and strategic decision to decide what you're going to do and how you're going to capture that innovation. But all of this has to be the strategy that you're using. And in my case at Philips, we had 12 different business units scattered around the globe, every different geography as you can imagine. And I had people planted everywhere. Wherever we had an R&D unit and a product unit, I had intellectual property attorneys there, capturing that innovation. And we captured it holistically, looking at how we file, what we file, and how we're protecting it with trade secrets and trademarks and domain names and copyrights, all different aspects of IP. It all collectively goes into a strategy. And I'll talk about that in a little bit. Why does it matter? Because it encourages innovation and it has a direct effect on economic growth, no matter what geography you're in. So industries deemed IP intensive by the PTO, for instance, accounted for a lot of jobs. In 2014, it's gone up much higher than that. 52% of US merchandise exports are attributable to IP, and it's unfortunately grown as the number of patents grows, then the number of weapons grows, and patent litigation violation cases filed goes up as well. What makes it difficult is that it's not had as much emphasis in education, right? So in business schools, and I don't know how much emphasis you have on intellectual property, but it's not as much as you would think. There's not a lot of courses around it in intellectual property law. If you're not a patent attorney, if you're in law school like myself, you know, there wasn't a whole lot of emphasis around intellectual property. It was a couple of courses or electives. And in technology, so it really wraps the three disciplines together. And you really have to know legally, technically, and financially how these things interact. So you're able to answer questions like, what is your trade secret? What does your patent cover? You know, just answering that is a non-trivial question. You know, if you launch this feature, will it infringe anyone's assets? Being able to go out and scour the universe and finding direct relevance from a patent claim to what you're doing is difficult. And if you're not doing some type of a landscaping of before you launch a product, you could become a victim of someone that does have a patent claim that might cover that. This is a great example. So this is a patent. If you know, I just mentioned the cell phone wars. This was an Apple patent that was subject between the battle between Samsung and Apple. Very expensive patent if you're Samsung. But basically, if you're older like myself and your eyes aren't all that great, you use your finger to pinch the screen on the cell phone to make the text bigger, right? That's what this patent covers. But if you look at it, in this box is one long run-on sentence, right? There's no periods in there. And that becomes the complexity because I've been in many jury trials and trying to, both on the offensive and the defensive side. And I've seen a lot of different juries. One jury in particular, we walked in and it was a case involving defibrillators. And the foreman of the jury was an 18-year-old boy straight out of high school who was, and this was in the middle of summertime, and he was a lifeguard, was miserable to be there because his only source of income was during the period that this trial was going on. Didn't want to be there. And we're arguing technical features of a patent claim like this and trying to dummy it down to a level that a jury can understand, and you're hoping that they understand it sufficiently that they will vote your way and you'll get a successful verdict. It's very complex, and you argue every element of the claim, right? So every claim is broken up into pieces, and you present it to a jury, and you're arguing back and forth on validity of patents and looking at the relevance of the claims. Very, very difficult. And the problem is that companies are focusing on quantity. And I'll talk about that in a second on why that bit me when I was at IBM. But over $40 billion is spent on patents, but less than 20% of companies report that their portfolio is the right size. Some say it's too big, a lot say it's too big, a lot say it's too small. There's very few that either say it's perfect, and some just didn't respond, but it's just not, you know, it costs a lot of money, particularly if you're a multinational company that is filing in China, in Europe, in US, and doing PCT filings and all different filing jurisdictions to protect your innovation. It costs money. Most patents never worked. there's a statistic, and you can read about this, and I'm sure your professor may have mentioned it, but 1 to 3% of the patents in your portfolio have any value. So if you're a company like mine at Philips with 75,000 patents, 1 to 3% of those actually have value. The problem is separating the wheat from the chaff, trying to identify those, what we called hero patents. That's what I called them at IBM. The ones that you can use either if, you know, in litigation, the ones that have been battle tested and tried and true and survived inter-party review challenges and prior art challenges and validity challenges and all this. It's difficult to find those, it's difficult to create those. But even fewer make money for their owners. So it's pointless unless they can be enforced by a legal action, right? Because don't forget, a patent is something that is a right, it's a negative right. So why do you bother? So this is a great example. So here I was at IBM. I'd taken over the role from Marshall Phelps, and I was participating in an investor relations interview with a bunch of press. IBM had just announced for like the 12th year in a row, I think it was, right now I think they're at the 25th year in a row or something like that, where they're the #1 issuer in US patents. And it's a very proud statement for IBM every year. And I had always cautioned the CEO that it's, you know, it's nice to have that as a bragging right, but you have to be careful because it's quality really you want to assess rather than quantity. Person raised their hand, it was a reporter, and asked me, he says, okay, so you're bragging about being #1 in patents. How about this patent? What does this have to relate to you to IBM's business? This patent, by the way, is actually quite nice, but it has nothing to do with IBM's business. Picture this, you're on an airplane, you have to use the restroom, and you look back there and there's a line of 10 people, and you're like, crap, I gotta wait for 10, 15 minutes for the line to die down. This solves that. So basically what you're doing is there's a screen in front of you, you put your name on there and you're on a waiting list, and it'll tell you when it's your time to go up. So when it's your time to go up, bingo, you're there. And so it has a queue and it updates the queue and all that, and you're notified when it's your. So it's a system and method for providing reservations for restroom use. Very useful. But how was I to answer that question, right, from a reporter that's saying, you are spending a lot of money on this portfolio of patents when you have plenty of patents in there that have nothing to do with your business. So why is that relevant? Why are you spending shareholder money on this? So it became a very difficult question. So quality is really what I've always been about in my various jobs and functions that I've had over quantity. And the problem is, in the USPTO, and China is dealing with that right now. China is out issuing and filing patents like crazy, but USPTO backlog itself is about 540,000. And they process 600,000 patent applications and issue up to 300,000 each year. So every 3 years or so, we're going over another million, right? So the issue, one of the issues regarding quality is that the patent examiner role, I wouldn't say I say it's a revolving door, because a lot of patent examiners will have the job, and when they become very good at issuing claims or prosecuting claims for a given technical area, they move on, and they move on to another job that's more high paying or whatever. When I was in Europe, it's completely opposite, because in Europe, at the European Patent Office, they don't pay any taxes. So you pay 0 taxes, and they pay you very well. The benefits are great, the vacations, it's just an amazing job, and it's a job for life. And so if you can imagine someone that's very well trained in a technology space, and you want that guy to continue to prosecute patents that are in that technology space, you want him to stay. And so it's a job for life as long as you want it. And that's why the quality of the EPO and a lot of their of the patents that they're issuing are very high quality. And a lot of it has to do with the examiner role. Now I'm going to touch on trade secrets, because this is an area that I think is I call it the little orphan Annie of IP, because a lot of companies forget about this. Remember, you have to make this decision on whether or not to file a patent, to keep as a trade secret, or to publish. But trade secrets and patents provide a textbook example where strategy and commercial strategy, IP strategy, commercial strategy come together. So a patents, you get an exclusive monopoly for 20 years in return for public disclosure of the invention. So you're telling people what you're doing. A trade secret, like the Coca-Cola formula for the syrup, is there's no time limit. But if somebody independently discovers it, right, then you're generally, you'll have no rights under trade secret law to prevent them from using it. So on the one hand, you have strong protection of a limited duration with patents, but you got to disclose what you're doing. On the other hand, you have perpetual protection, depends on how good you can keep a secret. So what route should you take? There's different reasons, and I won't get into them now, but as a strategist within a company, there's different reasons why you would do either one. But once you've made the initial decision to protect it, then you choose how to best protect it. And that's why you have to make these decisions. And that's why I call it the little orphan annie of IP, because it's really a difficult form and you have to follow the rules. There's something called the Defend Trade Secrets Act that was formed several years back, partially written by a very good friend of mine, Jim Pooley, who's actually out in the Valley, and he was a very good attorney that I actually have on retainer to help me with some of our trade secret practice that we've got. We've got trade secret advisory, we sell trade secret theft insurance, and helping companies understand. But DTSA requires you to do two things mainly. One is to make sure that you're identifying that you have created a trade secret and you've documented it. And you've documented when you first came up with that. And secondly, you have to go what's called reasonable measures to protect it. Reasonable measures, once again, depending on what judge you get, can be interpreted different ways. But if you get a trade secret theft, and this is where a lot of these cases now are becoming difficult because companies aren't satisfying those requirements. So if a trade secret is stolen and they try and go after the company that acquired it, if they acquired the employee and therefore they have the trade secret and they've implemented into products and they're eating into that company's market share, you know, they're going in front of a judge and the judge is saying, prove to me that it was a trade secret. That's a high bar. And secondly, what reasonable measures did you use to protect it? Obviously, it wasn't enough because this guy stole it, but you have to, and that's the requirement. And you see here that it can be all different forms of financial business information, very broad on what a trade secret can cover. But you have to do this, and it has to have independent economic value, actual or potential, from not being generally known to the public. What's changed with trade secrets is that the patent equilibrium has changed. So the combination of technology and market trends and court decisions on patent eligibility has altered the equilibrium. So you're hearing lots of things like 101 rejections or Alice rejections, because there's a whole body of patent law on business method patents, which are very difficult to if you're in court, to sustain, because a lot of those patents are patent subject matter that the judge might not necessarily agree that it should be eligible for protection. And so that has raised a lot of uncertainty and scrutiny and people scratching their heads on whether or not patents are the right thing for me to do. So they're saying, maybe I should do a trade secret. I don't have to worry about any of that crap, right? So that's affected this a bit. And this whole DTSA has helped offset the patent system, because now all of a sudden you can get injunctions and you can enforce trade secrets, and it's led to increased protection. And accelerated pace of innovation generally has caused trade secret protection as well. So this is a good chart here that really the largest cause of cybercrime is really theft of intellectual property. So 250 billion a year, which is 3% of the GDP, is just in the U.S. is the cause or is the result of trade secret theft. It's had a great role in this 85% of the value of intangibles. A large part of that has to do with trade secrets. But we've created this issue within the world that you're creating assets, but you're not protecting them, you're not securing them, and you don't have the right securities and policies and procedures and governance around protection of trade secrets that you would in patents. And if you're not doing that, then you're susceptible to misappropriation and trade secret theft claims. And one of the things at Aon, we have trade secret theft insurance and also intellectual property liability insurance as well to help protect in case you do have third-party claims. With some of the, we have a best practice trade secret advisory practice, and we help tell companies, okay, what do you do, right? So how do you protect these assets? Well, first thing is culture, right? I mentioned you've got the typically the head IP counsel will report to the general counsel or report to maybe report to the CTO. But you have to instill a culture at the C-suite that really embraces trade secret protection at all levels of the organization and across the company itself. Taking an inventory of what they cover is a very difficult task because we're advising a company over in Europe that had 10,000 trade secrets stolen by a Chinese national that went rogue and went to an employee or employer over in China. And so the CEO found out and was left holding the bag. And, what do you do? So we came in and actually helped them separate the wheat from the chaff. Like I said earlier, they've got thousands of chemical formulas that cut across multiple product sets and product lines and product divisions. And so when you have that instance, then you have to figure out what's critical. And the what's critical are the ones that have the most revenue impact if these things are stolen or misappropriated. That's how you define what's called a crown jewel. Crown jewel is an asset that you want to make sure you do above and beyond the most important level of protection imaginable for those crown jewels. And we advise them, those other, thousands of trade secrets that you have, we'll get to those, but let's focus on these first because those are the ones that you don't want your competitor to get because it's going to have an extreme detrimental impact on your revenue. So taking that inventory is very important. Developing a plan for how to respond. So an incident response planning is what we taught them. So if there is an incident, what are you going to do in the event of a breach? Look at third-party agreements, so joint development agreements, non-disclosure agreements where you're granting access to third parties to some of your trade secrets. You might want to do that if you're doing, some of these joint development agreements or merger agreements or whatever. But you want to log in who has access, whether an employee or non-employee. You want to have onboarding and offboarding procedures for your employees. You want to memorialize your policies and procedures, limiting your confidential information on a need-to-know basis. Have a way to delineate data classification to have different tiers of trade secrets based on value. And most importantly, to fortify and accelerate your physical and technical network security to make sure that you're protected. Now I'm going to talk about strategy, and I'll tell you how I did this at Philips. Professor Teece mentioned early on that I was able to take a strategic view of intellectual property at Philips, and the way that I did that was to come into the company, and every company has a strategic plan, right? Strategic plan is typically a 5 to 10 year roadmap of what is your product and solution roadmap looking like longer term, and that's where my focus was on intellectual property because patents take several years or longer to issue. And you're looking forward to seeing, so it's sort of forward looking. So the way that I did that was I said, I want my intellectual property strategy to be incorporated into that strategic plan on record for every business unit and across the enterprise in totality. So the way that I did that was we understood and we spent great lengths in understanding what is the longer term business strategy, what is the product roadmap looking like longer term, and how are we going to capture innovation now to make sure that we identify opportunities and roadblocks along the way. So if you're early enough in the R&D phase of product development, you can identify potential roadblocks. So in other words, you're having a design for a product, and we would do a landscape. Okay, who's generating patents doing what we're trying to do, or based on their filing history, we think they're headed in that direction. We identify those roadblocks, and we help the researchers understand that maybe if they tweak the design to do a different functionality a different way, they can avoid the roadblocks. And if you're early enough in the development phase, you can affect that product development in a good way. So that way you are going down a way that generates revenue, but you're also avoiding a lot of potential issues down the road, because you don't want to do this after the product has already been developed. Right? Because you spend millions of dollars on development, but you're also developing, spend a lot of money on manufacturing. And so it's a little late to change the design at that point. So that's how we did it. We went to each business unit and communicated what we were trying to do. And then we developed this IP strategy that dovetailed one-on-one directly with the business strategy and communicated that to the C-suite. I even went to shareholder meetings, to the, I'm sorry, not shareholder meetings, but the board of director meetings to communicate to the board what we're doing, what our roadmap was, what our IP strategy was going forward. So that's, and once again, it was by business unit and across the enterprise. So if you look at, and this is just a basic formula for profit, profit equaling revenue minus cost. So corporate strategy is really focused on being able to sustain higher prices than competitors. You guys have learned this in undergraduate and now in your MBA, to increase market share or maintain lower costs. Very simple. So as a contributor to corporate strategy, IP strategy has to pursue the same objectives. So you have to make a meaningful contribution to corporate profit generation. That's how it works. This is a great quote here from years ago, but really it boils down to really the last sentence, because you really need to listen to determine what your business goals are and how you wish to achieve them, and only then will the IP strategist suggest you move forward with obtaining cost-appropriate IP protection. So you have to really understand, be embedded with a business, understand the business needs at its core, and then understand how that translates to innovation. And be early enough on in the process where you're capturing that innovation right at the outset, and then you're documenting it and you're protecting it. So the culture, once again, has to enable its development and execution. So unless you are, and this was ingrained in Philips for many years, but unless you are part of that, unless you have convinced at very high levels within the company of its importance, it's just not going to work. You're not going to get the budget, and you're not going to get the attention that it needs. And the organizational structure guides the execution of that as well. So centralization, I believe, and I've always preached, is key. Structure. A lot of companies are decentralized, whereas the IP is owned by each business unit. The difficulty that brings is that each business unit makes their own decisions on how they grow and harvest that intellectual property stack. And if you have the centralized alignment, then you have a centrally driven structure, and the strategy is much easier to implement. Otherwise, you're having a lot of decentralized, it's at times ill-guided and misfocused strategies that are really centrally driven, and you're only focused on your own way of doing things. So global alignment's critical, central control, and proper alignment within the key markets. You're having what's called business to market combinations. So you're having businesses. That's the other thing we did within Philips was in China, for instance, a good example of a business market combination is our air treatment technology. So we have air purifiers in China, which was a huge business for Philips, right? Because of the pollution rate. Say within Shanghai, there were sometimes I go outside my hotel, I couldn't see across the street because it was so polluted. It was just ridiculous. And I'm a runner. I run 8 miles a day, and I literally couldn't run outside because it was unhealthy. And so Philips would sell millions of these air purifiers and make a ton of money. That's a business, and the demand for that was very, very important. So that business to market combination created an opportunity for Philips to sell these, and it created us an opportunity to create. And so we innovated the heck out of air purifying technologies over there because we knew it would take off. That doesn't sell here in the US because we don't have as much of an issue. A lot of people do have air purifiers, but it's not nearly the issue that we have in China. So that business to market combination is not particularly relevant here. So that's a good example of being able to envision how innovation can make a difference through these combinations. This is a good chart that shows how you're thinking about it as a strategist. So you're looking at what you want to achieve, right? If you want to achieve profits, then you're going to have some type of a commercial model where you might want to choose licensing revenue. And that was a large part of what I did at IBM and also at Philips that I'll talk about. Financial bottom line contribution, revenues and grant back, mutual settlements, or over on the right, exclusivity. This is when you don't want a license. You want to have an exclusive right to sell things in the market by having a portfolio that protects that innovation. So you have market exclusivity, you have premium profits that you charge. We were able to, excuse me, calculate the business impact of IP, and a large component of that was the exclusivity in the market, the premium profits you can charge on your products that no one else can because you have the patent strength behind it. So higher profit margins. On the bottom left, if you're into the cost savings mode, you could have a mitigating model where you'll have offsetting royalties or doing cross licensing. So that way you're trying to mitigate your risk, doing assertion prevention. So you want to have a portfolio. When I was at Philips, one of our biggest competitors in the medtech space around MRIs and CAT scans was Siemens Medical, Health and Years. And we both had huge portfolios. We didn't want to poke each other in the eye, because if I went to them and said, you owe me money because I want to sign you up for a license, they would poke me in the eye because they had patents as well. And so as a path of least resistance, we decided to sign what's called a $0 cross license, no balancing payment. So it was a mitigating model. Very easy. We both agreed to sign it, and it was great. And then finally, on the bottom right, you could do more on the injunction avoidance or litigation settlements, the defensive model, the freedom to operate. So when you launch a product, as I mentioned, you want to do landscape studies to figure out how you can sell that without fear of third-party litigation. So you do freedom to operate studies or those types of things, or product clearances. You'll hear that sometimes. So these are the four quadrants that you'll find yourself. And when I was at Philips, we had some, like in our sleep and respiratory business, we wanted exclusivity. For some of our other businesses, we wanted a commercial model, licensing revenues, right? So you could have more than one strategy for a company, but it depends on what, it could be segmented by business unit, could be segmented by geography, but you really have to define where these quadrants reside, and that feeds into your IP strategy. So now I'm going to morph a little bit about the investment community and talk a little bit on value, right? So why investors care about strategy. So intellectual property has no limits on its value. So tangible property depreciates, right? And IP protects a company and contributes to increase. So it's directly relevant to the company revenue streams. And so we're educating VCs and hedge funds on really what this means. And you can leverage it. You can use it collateral for borrowing, exclusivity value, freedom of action, premium pricing. It lessens operational risk because it creates a basis for scaling businesses quickly and extensively. And companies, excuse me, that protect IP are better partners because it allows you to be better and more suitable and actually a better acquisition target as well. And it can boost your marketing and sales activity based on, putting a registered trademark or patent pending on your products. Some of the problems is that you're unable to determine what that strategy should be. And we're helping to advise small and medium-sized clients to do that. You're not doing product clearances, or you're not doing freedom to operate studies. And so you're unable to look at what problems might exist from third-party IP. You may fail to file patents early, and so somebody might have beaten you to the punch. Failure to obtain assignments from early employees, so as they go to other companies, it could become a problem, or determining what the right mix of IP should be. And so the strategy should really to do this competitive assessment, landscape assessment up front, analyzing some of these competitor portfolios, monitor patent filings in the markets of interest. So looking at what are the competitors, non-traditional competitors, and even patent trolls, what are they doing? And how does that affect you, either as for you to get acquired or for you to acquire one of these smaller competitors? And look at active inventors for potential hiring as well. Very important. This is a great chart. So I'll give you a real life example here. So we're talking with VC and private equity on some of the due diligence that they do. I talked to one VC about a year ago, and I asked them, what kind of due diligence do you do on an acquisition target? And when it comes to if they have a stack of patents, and he said, well, if they have 10 patents, then that's great. I'm going to check that box off and move on to the next thing and see what, really they're focused on business revenue impact. And I said to him, well, those patents, The problem is are they related to toilet seats or semiconductors, right? I mean, you really don't know unless you dig into the details of the claims. It's all about context, quality, and relevance. You have to look at the relevance of those patent claims to what they're doing as a company and looking at the value that that represents for the company. And the light bulb went on with him because it really is, it's an art and a science of being able to understand what that relevance means and how to translate it into value. And I'll tell you what I mean about value. This is a good example. We advised a client, actually it was a Silicon Valley client, that came to us with a problem. They were developing a mobile, easy-to-use video editing app. That's what they were doing. And they're like, what does the patent landscape look like for this? Because I want to develop it, but I don't want problems, right? So we looked at the landscape. We said it was a relatively new innovation space. A lot of assets originated after 2010 with 20 grants and 15 patent applications. And you see the color coding there, the different areas. But there were different competitors grouped by technology, whether it's capturing multimedia, user interface mechanics, and all of that. So we looked at, and who were the players associated with this? So you see the ones on the left, Twitter and Snapchat and some of these others. They were the owners, and you can see the relative ownership percentage over on the right. But we noticed when we did this study, you see the circles that point to where a lot of these were centered, but there was no dominant player when you combine video and audio integration together. They didn't ask us to look at that, but we noticed that from looking at just doing a simple analytics profile of this, because it was all concentrated in message storage and real-time messaging. So what we did with that was we pointed to that and we said, here's some key areas for next generation when you combine the video-based messaging app and implemented a targeted build strategy to seize an opportunity that you see over there in the red. There really was nobody that was focused on that. So we helped them to build up their portfolio. And as the net result was that they had an early post-launch acquisition. They were acquired by a Fortune 50 company for a premium based on what we did for them. We created a portfolio that created assets where no one else was focused. It was a differentiator and it created value for this company. So it shows you the power of innovation and how it can result in a bottom line, in this case, a premium value for this company. So now I'm going to talk a little bit about risk just for a few moments, because risk is also an element of IP that you should be recognizing. Whether or not you're in any of these people here, we're trying to understand what risk management means. And when it's not properly managed, the cost of, in the case of patent litigation, can be sizable. So the yearly average cost of all US patent litigation is quite substantial. And most of it goes to smart attorneys that are making a lot of money on legal costs. The combined total, $19 to $36 billion. And depending on the amount at stake on the bottom, you could spend, whether it's what's called an NPE or non-practicing entity, these patent trolls, you're having to spend money. And you're going to spend a lot of money and if you're ill-equipped or not protected, then it could be quite substantial. Here you see litigation from operating companies and NPE litigation, which has grown over the years. You see how that's grown exponentially, and it's becoming a larger problem. So it's becoming a way that companies have to think about how to mitigate it, whether it's through an insurance policy you might get from me, where we can help to mitigate it and protect you in case it happens. But more importantly, on the front end, you have to go through the precautions of being able to clear your products and being able to address some of the legal issues that present themselves. Now I'll talk about value. So because this is an important discussion. So this was a great discussion I had with my CEO. I mentioned Lou Gerstner. He was a great, insightful CEO. I was on the job maybe a couple of months, and we were generating, by the way, every year that I was there, we were generating about $1.6 billion annually in licensing revenue. And that was a combination of brand licensing, patent licensing, and technology licensing together. And it was a big amount, and it really, IBM relied on this revenue. But he said, what's the value of the intellectual property? And he claimed this 1.6 billion was the amount. And I said, absolutely not. I said, that's not. I said, give me a couple of days and I'll come back to you with the answer. And we were still selling ThinkPads at the time. We wound up while I was at IBM, we sold that business to Lenovo. I was part of that. And by the way, that deal, that Lenovo deal, we were able to count over half of that money as intellectual property income, because what they wanted was, see that red dot in the middle of that ThinkPad. They wanted that, which was great. They wanted all of the patents associated with protecting the ThinkPad and the PC business that we've got. They wanted the ThinkPad name. They wanted the logo. And so all of that was intangibles. And so we valued that as part of the transaction. Was a very significant portion. Anyhow, so I go back to his office, and I had the lid of this ThinkPad lifted up, and it exposed all the guts. So you had the hard drive, you had all the different aspects, and I had a sticky flag. I had 250 sticky flags pointing to different pieces of the inner part of the device. And I showed that to Lugersman. I said, this is the value. The value is that without each one of those flags represented a patent, an IBM patent representing part of that device. Without those patents, we would have 250 probably plus litigations from other companies out there that have related patents to what we're trying to do. So it was a freedom of action thing. That's the value of the portfolio that we got, is the ability to sustain the revenue stream, not the intellectual property revenue, but the total revenue of the company. That's the value of intellectual property, and he got it. And it was sort of a transformational moment for him. So it's not the revenue generated from licensing, it's really the impactful revenue, being able to sell the products and services unencumbered through the portfolio. The valuation approach that a lot of companies use now are focused primarily on quantitative analysis, which is the middle portion here, which is really looking at different, and you probably have gone through maybe some of this methodology in-house, but there's a cost method, a market method, or income method. You could use Black-Scholes analysis. You could use a different kind of discounted cash flow, do net present value analysis, et cetera. But you're really ignoring the left-hand side of the equation, which I think is equally as important, which is the foundation, the qualitative analysis. At Aon, we've got 3 different metrics associated with it: coverage, opportunity, and risk. So coverage, looking at the IP in question, what does it relate to? How does it relate to the revenue stream that we're trying to value? And from a qualitative angle, what does that mean? The opportunity, what does that represent, right? So if you've got a patent claim that you're selling semiconductors, and the patent relates to a semiconductor process methodology, but it also relates to other use cases, that opportunity could be much larger than what's intended, or than what you're actually recognizing. And so that opportunity could be actually greater than what you would see in that quantitative analysis. And then the risk, what can actually detrimentally take money away from that quantitative analysis by looking at the patent claims themselves, if they're in this sort of business method patents, or some of these areas where maybe the patent claims are too broad, too narrow, there's prior art that you might identify. And that is sort of the qualitative aspects that you would want to combine in the quantitative to get in practice how it would value. And we use that valuation for this product that I'm going to talk to you about right now, which is collateral lending. So I'm just bringing this as an example of how powerful and impactful intellectual property can be. You're the IP holder. You're generating money. You're trying to borrow money, and you've got 3 different ways to raise capital. One is through traditional cash flow lending. So, that's sort of limited. It's difficult to get at times. You could get equity or dilutive lending, or dilutive structures, very expensive. You could give up 25, 30, 40% of your company to get money. They'll give it, but they want a big piece of the pie. Or you can do what I call hard asset lending, which is higher interest rate and lower amounts you're going to get. What we're doing is we're sitting in the middle between the IP holder and the IP lender. Actually, we're going a step beyond that because we have our own fund within Aon, so we're doing direct lending. But basically, think about it as a pure debt instrument. So you're raising pure debt, and you're getting a loan that has basically in the high teens, mid to high teens coupon rate, that shaves percentage points off, many percentage points off a traditional equity raise. And you're getting the money much cheaper, and you're not giving up that precious equity because it's pure debt. So, and it's based on your IP as collateral. And it could be patents, it could be based on your trade secrets, it could be based on trademarks, it could be based on data. We're lending money to a company now that is using autonomous vehicle data. as their collateral. So, and what we're doing as a part of this is wrapping insurance to protect the lender in case of a default. So what we're doing up front is valuing this intellectual property as a going concern and as a liquidation value in case there is a default. But it's a unique way for companies that have good intellectual property that are trying to go post-Series A, that are trying to raise money, that don't want to relinquish that equity to get a pure debt structure that makes a heck of a lot of sense. And so we've got about $2 billion worth of pipeline deals right now. We just signed a $100 million loan to an agricultural firm the other month. That's a great instrument. So the issue with, and I bring this up because private debt continues to be a strong institutional asset class. It's got, there's $850 billion, the global private debt assets under management. And there's total private debt capital raised of $104 billion, and there's a lot of dry powder out there. There's $270 billion waiting to be deployed. But 84% of the investors are seeking to commit more money to private debt this year. And there's been a lot of deals closed with an average deal size of over 50 million. So with a lot of dry powder awaiting deployment and a lot of managers competing for the deals, the spread compression is likely and alpha generation may become more difficult to come by. So it's left meaningful opportunities to lend to growth companies. And using, despite the rise in what I mentioned with this whole intangible asset value, a lot of these growth companies are struggling to tap a lot of these credit markets. And a lot of the managers we're talking to, a lot of the traditional managers are lacking the expertise and the knowledge of the value of IP. And so we're educating them because what it's done is less significant white space in the market. And so with all the equity out there, the growth equity capital, we're looking at the IP-backed private credit, which is intersecting the growth equity capital and the private credit to give you the intersection of these two investment strategies into a relatively untapped market. And so what we're looking at is the cost of capital by source is very expensive. So equity capital for a successful startup, you see the percentage there, and we're over on the left, which is a debt-only structure with an insurance wrapper, 12 to 18%. So it's a very unique situation. I'll get into one chart here on an example of one of the companies that we're lending money to. So this company came to us. They're a health products company that aims to address the global health issues around medical dehydration, protein imbalance, and diseases like cystic fibrosis. Founded in 2017, they're looking to raise $60 million in debt financing. And the use of the proceeds was really to use as operating expenses for continued R&D to get more products out, more medical products research, development of the portfolio of products, and the debt's going to be senior secured and collateralized by the company-owned IP and tangible assets. So it's pure debt structure, and and so we're using this, and we looked at their business plan, their revenue projections were very, very good, and they had a great balance sheet. So this is an example of how early stage company with just starting to grow can be very impactful and be a good example here. The final example that I'll bring you on is a monetization example that's quite exciting that I did at Philips. So the background of my organization there was, so I was the CEO of a business unit within Philips called Intellectual Property and Standards. So it was a standalone, separate business unit within Philips. I had my own P&L. We were generating about $650, $700 million a year. 85% of that was EBITDA, right? So EBITDA positive. So we wound up capturing a significant portion of the overall EBITDA results for the company. It was pretty astounding. But with the ability to have my own P&L, by the way, that's very unusual for an IP department to have their own P&L. I think there's only maybe a handful, 2 or 3 companies that can do that globally. I was able to have, and by the way, it was generated through patent licensing, technology licensing, brand licensing. We did some IP sales, and I did what's called IP ventures, and this is where I wanted to focus a little bit here. I mentioned that I was relocated to the right next to R&D. That's where I had my business unit headquarters for IP&L. And so we worked with the R&D. Unfortunately, R&D had a lot of orphan projects because they can't fund everything, right? 10% of the revenue of Philips went into R&D, but a lot of those were defunded. And so I would have my guys over there, and the second that they saw one of these defunded projects that had great IP and it had good market potential, I would raise my hand and say, I will fund that project to its completion. So I would take over some of these projects, continue the funding for roughly 18 months to 2 years to complete the funding process. And I would set up a standalone venture. And so these ventures would sell product or sell services. I would appoint one of my IP guys as the venture manager. So basically be the CEO of this little entity. And I had 8 or 10 of these that I was funding, and they all became profitable within 2 years. And all 100% of the funds of the profit that was generated came back to me and sort of fed back into my ecosystem. And I was able to sponsor more research projects and all kinds of stuff. And I would seek external VC funding when I needed to do as well. Once again, I bring this up because it's a very impactful way to show that innovation and intellectual property can be a direct contributor to business growth, and it can be the seed foundation for companies to really generate revenue streams and able to capture and really recognize the ability to capture value and recognize value. So what does all this mean? This is the end of my presentation. I wanted to allow a few moments for some questions, but this just means I hope I instilled a little bit. I ran a little scattered, I think, and the reason, and it was actually purposely so, because I wanted to hit a lot of different topics to kind of mainly focusing on strategy, but also value, and throwing in a little bit of risk component in there as well, because I think all 3 of those are very important to recognize as a company, particularly as you go into the workforce. Some of you are already in positions, and I applaud you for completing your degree as you're doing that. That's how I completed my my post undergraduate work as well, as when I was employed. And but those of you that are going to go out into the workforce, most certainly think about ways that you can impact your future employer by thinking about innovation and thinking about ways to capture it, thinking about ways to make a difference in your company, and most certainly being intellectual property as a means and an ends to do that. So I'm going to pause here and see if there are any questions.
Brian, thank you very much. It was a very broad canvas that you covered there. Just to kick things off, you mentioned that at Philips there already was a culture that sort of accepted the value of IP, and I guess that was true at IBM where you were. It's true of other companies like TI, but there's others where it's not true. So what is it that leads some companies to better understand, if you will, the role of intangibles and to make it a key part of their strategy, and others that don't? Is it purely educational? Is it something about their history? Is it something about the CEOs? Why do some companies get it and others don't?
I think there's a number of ways to answer that. A lot of it does have to do with the nature of the culture within the company. Some of them are more resistant to change, and so they're caught in a way of doing business, and it doesn't facilitate the need to change to foster that type of innovation. Now, the world has changed, and I think more companies are starting to appreciate it because of the fact that we are a very litigious world, and so they are waking up to the dangers and the risks that I pointed to, and as well as being a way to capture revenue. So companies are, but you have to really understand how the mind works within a C-suite, because they're focused on revenue, right? You have to recognize that they're focused on near-term results. They're worried about next quarter and the quarter after that and next year, because that's, the CEO has to answer to the shareholders and to the board. That's where they're focused. You have to show them what the impact is, how you can impact near-term results, but more importantly, the longer-term focus, so that way you can actually focus on that. The more that you are able to show the direct results and make it meaningful for that particular audience. To a CFO, I would focus a lot of time on him because everything has a financial impact. The more insights you can create to him to show how you can save costs. You're not just a drain on finances, because mostly when they think of a patent attorney, they're thinking, how much money do I got to spend this quarter on my patents? I'm spending all this money. Where's my return on investment? You have to answer that question. You have to translate that into a way to show, here's the results. And you have to translate that, what I call business impact of IP. And there are ways to do that, to translate that value. And once they get it, that light bulb comes off, you get approval for the budgets, you get approval to spend, and you're able to show the revenue associated with your results.
Okay, and let's see, we got some questions from some of the class members.
Yeah,
here.
so let's see. So Rachel, then Christian, then John.
Go ahead.
Thanks. My question is, can you expand on the point you just said about there are ways to show the financial impact of patents and how to do that? And then I think before you said that, I was thinking about like, how do you as a company assess the value of IP in order to issue the debt against it?
Yeah, so, okay, so I'll answer the first question, which is on the value. So the way to measure the value, and it's not an easy task, I spent, I spent 4 years in the Netherlands, and we built this sophisticated revenue or business impact model over the span of a couple of years, and it contains several components, a lot of components actually, but the main ones were obviously is revenue that you can achieve from licensing, but that's one of minor component. The exclusivity that you have in the marketplace. I mentioned this premium profits. There's a way to calculate. You've got a strong patent base that enables you to sell product, and by virtue of knowing the landscape of patents that are out there and being able to reflect on what that premium profits are, what that measurement is, that would go into the calculation as well. The degree of exclusivity that you've got within the marketplace. There's all of these different impacts that you've got, but the bottom line is, what is the portion of the revenue stream that you've got, say, within a product unit? So if you've got a strategy within a product unit, you sell $10 billion worth of product. Of that $10 billion of revenue, how much is directly attributable to that intellectual property stack that you've got? So how, you have to look at areas like patent coverage, right? So your patents cover a lot of features of the products, but they cover everything, right? And to the extent that you can show that and reflect that in your results and show that through this ROI calculation, that's, those are some of the ways that you can show how that value exists within an organization. The second answer to your question, to substantiate the debt funding, we try and get a value, what's called a loan to value of about 30 to 50%. So what we're doing in one of the cases, that one company, by the way, that we lent $100 million to, the IP was valued at about $300 million. So we had a loan to value of about 30%, which is good, because then at the end of the day, if there was a default, you could sell that IP for more than what they borrowed against, right? You could sell it for $300 million if they wound up defaulting on the loan. But the way that we valued it is, I mentioned we do this qualitative perspective of measuring the qualitative coverage, opportunity, and risk, and combining that with the quantitative valuation to give you an overall perspective of what that value is as a going concern. So we look at their business plan for, in this case, it was a 3-year policy period, so a 3-year loan. And, what is their revenue going to look like over the 3 years? And then we would look at the direct correlation between the IP. Does it substantiate that revenue stream? And we would come up to that value.
Great. Christian, I think you're next.
Hey, Brian, thanks for joining us tonight. It's super interesting to hear about all your experience, and especially I really enjoyed the Bill Gates quote. That was really cool. My question is about, for early stage companies, startups, especially Silicon Valley type, that pivot a lot and change. Maybe what they set out to build will be radically different, like 6 months later after they start. How soon should companies think about buying patents, and how much should they focus on it? Because it does take, I think I filed a few patents for my current employer. It's actually a bit of work to get it right. So just curious what your thoughts are there.
Yeah, I mean, if I'm a small company, you've got limited budget, right? So you've got to think about, starting as you're innovating, you want to make sure you're capturing it somehow. So patent filings are very important. Even if you're doing provisional filings, you're doing it just in the U.S. initially and then expanding overseas. There's ways to do expedited patent processing so that you can get a patent quicker rather than, the lengthy process that we've got. So there's different ways to expedite, but think about it as quickly as possible because of the fact that innovation changes. Companies are out there patenting, and so you have to at least know the landscape. If you're going to patent yourself, then at least know what your competitors are doing, where they're patenting, and to know what roadblocks exist as you're innovating. So as you're doing product development, make sure you know what you're getting into, because a lot of companies wait for startups to reach a certain revenue level. So they won't attack you right away, but then once you start eating into their market share or start making good revenue, you become a target for them. And they know you don't have the income and the resources to defend yourself and through a lengthy court case. So it could get difficult. So patent protection is very, very important.
Thank you.
Right, John, then David.
Yeah, thanks so much, Brian, for being here.
Sure.
We've talked a bit in class about how IP protections differ really greatly by industry and are much stronger in certain fields like medical devices or some things you've talked about. I'm curious how you think about the role of IP with a lot of the software companies today, especially many of the big ones who've sort of taken over the world, Facebook, Google, TikTok, the ones who are propelled by positive feedback loops. I was curious, for some of these companies, it feels like even if you were to be able to copycat like 100% of their software, you would still have a really hard time competing with them. So the data and networks seem really key. I was curious how you think about those types of companies.
Yeah, and software patents were kind of fell out of favor for a while. Now they're coming back as far as being able to enforce them. So depending on what the company is doing, and a lot of these companies are growing very, very fast. You see companies like Facebook, for instance, that have been, in the top 5 of the S&P 500. It's becoming exponential growth. But with that growth becomes a lot of challenges being able to substantiate the growth, and so I think it becomes, software is one of those industries that the patent base is growing. So you're seeing a lot of companies growing their portfolios. Microsoft is one, right? So Microsoft has stepped up their patenting, particularly in the last 3 or 4 years, has become in the top 10 in patents. So a lot of their software methodologies are becoming patented, and so I think it's becoming a more challenging space, a more crowded space. And I think, as more and more small software companies emerge in the Valley and throughout the US and worldwide, once again, you have to do this sort of landscape of the features that you have within your software. How innovative are they? And have they been protected? Have they been in use somewhere else? And so that becomes a challenge for companies.
Right. Let's see. David, I think.
Hey, Brian. Thanks. Yeah,
I have another question. Is there another question waiting there, Ian, or not?
Yeah. Sorry. David Holm has a question.
David Holman, thank you.
Brian, thanks. This was super interesting. This is more of a tactical question, but I guess how would you recommend that companies, especially like startups, go about documenting what their IP is? Because I'm just thinking, like, by documenting certain classes of IP, it goes against like the very nature of like what the particular IP is, like especially trade secrets. Like, how would you even go about documenting it and trying to assign value to it? You don't necessarily want companies to know what it is.
Once again, you make the conscious decision. So say you're a company and you decide to file a patent. That's easy, right? So you go and you get a patent attorney, and then you file the patent. It's a trade secret. As I mentioned, there's different ways that you have to go through these reasonable measures to keep it secret, but defining it and to make sure that you got different data classification. You have to understand whether or not it's just confidential information you want to keep confidential, or whether or not it's actually something that it's something that's going to impact revenue or impact cost, right? So that's a good way to think about a trade secret, as far as whether or not it's the relevance of it, right? So if it's got something, a feature within, as I mentioned, my Philips example, it's something that particular manufacturing process was innovative and something that was distinct from anyone else in any other company in the world, but it was a way that we were able to point to that feature and we grew revenue as a result. It was a feature that we had a closer shave than anybody else because of the way we manufacture these heads. That's how we thought about trade secrets. So if you're an IP attorney or you're an innovator and you have some of these ideas on ways to improve processes or to cut costs, there's different ways to think about it and different tiers of trade secrets as well, whether or not they, to the extent they have revenue impact, to the extent they have these cost savings measures. But being able to document those, very important to carefully document what it is in detail. Make sure that you're documenting and controlling the access of who has access, and you want to document when they first gained access and who it was, so you can later prove if they go somewhere else that that January 1st, 2018 they found out about this, and keep it to a limited number of folks, and then keep it, most importantly, into a secure repository, so that way it's got controlled password access, however you're doing it in-house. We have a blockchain-based trade secret registry, for instance, that we're using at Aon, that we're selling, that basically takes a fingerprint of all these assets and it stores that fingerprint on the blockchain. So that's a good, secure way to reflect this, but very, very important.
Thank you.
Ian, do I have room for another question?
Yes, go ahead. Thanks.
Yeah. So, Brian, even before the trade war with China, there was data showing that European and American and Japanese company were some were withdrawing from China because they were disillusioned that their IP had been sort of stripped, and then the market was moving away from them. So we've placed a lot of value, or you did in your talk, about capturing value, but there's also losing value. And some companies have done a pretty poor job of protecting their IP. Sometimes have licensed it, taking a short-term benefit, but then, getting serious competition as a result. So how do you look at all of those issues? It's the other side of the coin. It's not so much about capturing value, making sure that they don't lose their IP and that it's not prematurely licensed out, because I have a sense a lot of public companies, can get a short-term hit to earnings. I mean, you mentioned at Philips how it was a very important part of the earnings, but there can be a temptation where that's true to sell too soon or to license too soon. How did you balance that at Philips? How do you deal with a strategic rival like China, and what experience do you have there?
So I think when it comes to licensing, that's another strategic decision, and you have to figure out why you're doing it, right? So if it's, by the way, most of the licensing we did at Philips was in non-core, non-strategic areas. So areas that, to answer your question, we didn't care that we're licensing it to companies we wanted them to make as much money as they could so we could make money off of licensing royalties. And so it was a conscious decision for us to do that. I didn't want to license in areas that were core to the business. To your point, I didn't want to enable competitive, because the more they bought, the more they sell, that eats into my market share. That's not what we want to do. We wanted exclusivity. Now, when I was at IBM, we had semiconductor, this is back when they had semiconductor business, and we had a semiconductor process methodology that we wanted to have as an industry standard. And so we wanted the industry to adopt this technology. And so we licensed, even though it was core to IBM's business, we were making a ton of money, we wanted the industry to accept it. And so we licensed it to Sony, and we licensed it to these TSMC and UMC and these semiconductor manufacturers. And once they adopted it, as we went to the next generation technology, on a drug, they wanted that next generation because they wanted to continue to evolve as well. So we will continue to license them the next generation. They would make money and we would make money, but it became known as the IBM standardized way of doing this. Similar at Philips, our lighting business, we had LED we wanted LED standard. And so we had a big lighting business, but we licensed every LED manufacturer on the planet because we wanted them all to adopt this technology and patents that we've associated with it.
Okay, so if it's licensing standards technology, that's one thing. If it's non-strategic, that's okay, but you had a carve out for certain areas that you wouldn't license. So, you go back to your razor, I suppose you weren't licensing too many parts of that.
Right. So what we would do there is you could license, there's other reasons you would license the technology that's core to your business, but to your point, in a field of use that's not core, right? So as I mentioned, you might have patent claims that are, I'll give you an example. So IBM, we had a microwave curing technology that was for the laminate for printed circuit boards. So that green plastic material that's on a printed circuit board, we had a microwave curing technology that zapped that and basically cured it in seconds, and it shaved a lot of time and cost expense. Our technology also was applicable to other use cases. I had a guy from Procter & Gamble it was Kimberly Clark came to me and said, I want to use it for inkjet printing for elephants to put on diapers, right? And so they wanted to use that microwave curing technology to zap. They had these huge curing machines to cure the inkjet printing onto the fabric, and it took a lot of money in a huge warehouse full of machines. And we had a very small machine, very quick and very inexpensive process. He got an exclusive license. I made millions, but we didn't give up our core business, even though that technology was adapted for that, but it was a field of use that was outside that core use. So you can still have a core business and license in that core business for different fields of use.
Got you. Well, do we have another question there?
Unless anyone else has one, I don't see any others.
Okay. So, Brian, thank you very much. Two housekeeping questions. First of all, are your slides proprietary? Are you willing to share them with the class,
Yeah,
or at least some of them with the class? Because
sure, yeah, I'll send it.
Like that. Thank you very much. And if they want to email you with any questions or follow up, you're okay on that?
Please, I'd encourage you to do that. Yes.
Oh, fantastic. Well, there's a lot there to digest, and we appreciate it very much. And we're so happy there are people like you that are thinking out of the box and driving this kind of agenda forward, making companies more sophisticated around the technology space. So thank you so much for sharing your time this evening.
Thank you so much, and have a good night.
You too.
Thank you.
Bye-bye. Okay, class, well, let's have our break. We'll resume at 20 to 8, and I'm hoping to finish a few minutes early tonight. So let's take our 15 minutes as usual. And when we come back, I circulated quite a number of slides, but I really want to focus in particular on the Sherwin-Williams story. We've been talking so much about high-tech firms and dynamic capabilities. I want to take a relatively low-tech firm, certainly not a Silicon Valley screamer, but one of America's oldest companies, because dynamic capabilities is about long-term competitive advantage. And here we have Sherwin-Williams, a very successful company that's been going for over 100 years, well over 100 years. And there's very, very few companies out there that you can find that have a 100-year history. So they've got some special secret sauce, but when you look closely at it, I think you'll find it aligns rather well with dynamic capabilities. So while you're taking a break, maybe if you want to pre-read any of the slides, look at the ones from Sherwin-Williams, because that's where I'm going to go when we start. See you soon.